It's better than I expected, to be honest, because at least having set out how we're going to be told that we can't legally have a referendum, which is without any question what the UK Supreme Court will find. All you have to do is look at the Scotland Act, and she says, this isn't decided. It really is. It really is. Mm-hmm. There might be some kind of wobbly bits in it, but basically the Scottish Parliament was set up as the Scottish executive of Westminster. And that makes it directly answerable to Westminster. So one way out of that absolutely is a plebiscite election. And I didn't really expect her to say that's what will happen, but she has. So it's better than I thought. But it's a huge missed opportunity because she came in with the claim of right. And that has been accepted now in Westminster in three major votes. In 1989, the principle of the sovereignty of the Scottish people was accepted. In 2012, it was voted on. And in 2018, it was voted on. Now, the Scottish Constitutional Convention that put forward this notion that the people of Scotland are sovereign as something distinct from what applies in England, didn't have any legal force, and they didn't pluck it out of the air. They didn't say, what a good idea, let's say the people of Scotland are sovereign and see what people think of it. And they didn't go for the claim of right, 1988 and 89, by plucking it out of the air either. They were basing it on Scotland's document, the parallel document to the English Bill of Rights, which is the Claim of Right Act of 1689, in which the sovereignty of the Scottish people is established. And it's not a sort of make-do sovereignty. It's not one that says, well, if the people really want something, and we can show they want that, then they can have it. It's a very robust sovereignty. It's a sovereignty that limits government, and it's a sovereignty that says the people are the final authority in Scotland. And it's something that's been deliberately hidden and misrepresented for a long time. And she had an opportunity today, and she did mention it, just to go for it, to say, you will remember Lord Cooper's obiter, which has been repeated to this Parliament and multiple times, where he says that the principle of the absolute sovereignty of Parliament is a distinctly English principle with no equivalent in Scottish constitutional law. I'd have liked to hear her ask, what is Scottish constitutional law? What was he referring to? You don't have constitutional law without a constitution. Mm-hmm. And if the Scottish Constitution makes the people sovereign, and it doesn't do that in England, then we need to know what our Constitution does say. Because in Scotland, we may be, and this is what I would like her to have said, Mr. Johnson, we may be answerable to you, subordinate to you, under the Scotland Act, because we are the Scottish executive of the Westminster Parliament. But you, in Scotland, are legally answerable to the people of Scotland, and they are in authority over you. And if they voted us in, then we have to, if you're answerable to them, so are we. And if they voted us in on a platform for independence, I'm sorry, they're a higher authority. And if the Supreme Court has accepted parliamentary sovereignty, and this is really important, it does not have the competence to decide whether the people of Scotland are a higher authority or the Parliament is a higher authority, because they've already, as set up by Westminster, acknowledged parliamentary sovereignty. So there's a huge opportunity to talk about what's lawful. And she has simply accepted that what the Supreme Court of the UK says is lawful is lawful. What Westminster has said is lawful is lawful. And in many cases, it's not been. It's not now, because they are answerable to the people of Scotland. And I wish that